Hey everybody, John Skiba here, and in this video I'm going to share with you one of the most commonly misunderstood concepts when it comes to dealing with debt collection lawsuits, and that is the statute of limitations. We're going to talk about what it is, and maybe more importantly, what it's not, and how you can use it to win your debt collection lawsuit. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check off that little bell. That way you'll be notified each and every week when I put out a new video that can help you deal with your serious debt problem. All right, let's talk about the statute of limitations. When people call into my office, particularly if they have a judgment against them and they're getting garnished, often they'll say to me, how can this be possible? This judgment is from 10 years ago and they're still trying to garnish my wages. Hasn't the statute of limitations expired by now? When clients tell me that, what I'm seeing there is that they misunderstand what the statute of limitations is. Now, the statute of limitations deals with the amount of time that a creditor has to sue you and obtain a judgment. So this is well before the lawsuit's even filed. This refers to the time period when the account first goes into default, and then each state has a statutory period where the creditor can bring a lawsuit against you and try to get a judgment. Now, what that period is different in each state. If you look in the comments, I'm actually going to put a list of all 50 states of what I have been able to find are the statute of limitations that apply to credit card type debts. Don't hold me to this. It may be accurate. I believe it is, but I don't practice in all those other states. I know Arizona, and we'll talk about Arizona specifically in a minute. So it governs that time from when you fall behind on your credit card and then how many years they have to sue you. So, for example, in the state of Arizona, where I practice law, the statute of limitations on credit card debt is 6 years. So from the time that the account goes into default, the creditor has 6 years to file a lawsuit against you. If they don't bring the lawsuit within that 6-year period, they're barred forever from doing so. Now, when that begins, as far as when the statute of limitations begins, can become kind of a contested issue in a lawsuit. Often junk debt buyers will say that the statute of limitations begins when the account is charged off. From all my reading of the case law, I don't believe that that's true. Charge-off occurs 6 months after the last payment is stopped. So once there's 6 months of no payments, the creditor will charge off the debt. However, if you look at the terms and conditions of the credit card, default occurs once you miss a payment. Once it's 30 days past due, that's when they could technically sue you if they wanted to. They often don't until you get 6 months past due, but they could. And so that's when the statute of limitations would start to run. So as again, in Arizona, they have a 6-year period. That 6 years, that clock starts ticking 6 years from the time that you missed that first payment. So what if you get sued by a creditor and it's been longer than the statute of limitations period? So for example, again, you're in Arizona. It's been more than 6 years since you first defaulted on that account. Then what do you do if they do sue you? Well, you can file a motion to dismiss the case alleging that the statute of limitations has expired. You're going to have to be able to provide the timelines, the dates, all that kind of stuff to show that it has. And then once you do that, then the junk debt buyers put on notice that they've got to come in and show that the statute of limitations has not expired. Now, many people, they kind of mix up the statute of limitations with the amount of time that a civil judgment is good. So, for example, in Arizona, once a judgment is entered by the court, whether it goes through trial or summary judgment, whatever it is, if there's a judgment that's been entered by the court, that judgment is good for 5 years. And then in Arizona, it can be renewed every 5 years for the rest of your life. It'll hang around. It'll hang around forever. That's why you want to avoid judgments. So that's different, though, than the statute of limitations, which refers to the time period before the lawsuit's even filed. That time period is only when deals only with from when the account goes into default as far as then the lawsuit's actually filed. So if a creditor, if it's been, again in Arizona, if it's been 6 years, if it's been, let's say it's been 5 years and they filed a lawsuit, even if the case has been pending for a long time, even if judgment has not been entered yet, statute of limitations is no longer on the table because the lawsuit was filed within that 5-year period, which puts it well within the 6-year period of the statute of limitations. So hopefully that's clear as mud. But the main thing to understand is that the statute of limitations applies to the time period before the lawsuit's even filed. Once it's filed, once there's a judgment in place, generally statute of limitations is not an issue. It is something to look for, though, if you've been sued by a junk debt buyer, because often they will file lawsuits that are right on the edge They're right near that limitations period expiration date, and it could be a strong defense to either get the case thrown out or even settle it for less than the amount that's actually owed on it. I hope that helps today. Thanks for watching.